2016 পাবে না তো বলে দিচ্ছি 1K marks obtained in oral interview, lecture demonstration, and prior teaching experience. Therefore, prior teaching experience, if at all, stand the scrutiny of Article 1416 can only be considered after the preliminary screening is over, not before that. This is at the final merit stage. What they are doing, they are giving additional 10 marks to hoodwink the meritorious people at the preliminary stage. Though rule does not permit so. This is my very categorical submission, and kindly also come to my lord the schedule. Again, I would say, my lord, the statute makers, my lord, do not waste any word. Schedule 2, written examination, OMR, then academics. Where in the parent rule, they say, my lord, academic. And why these academics? When you bring prior teacher experience, this is not really declared academic qualification. And you make it academics, even assuming this is part of academics, but this would not come when you are preparing the interview list. Therefore, 10 marks cannot be given, if at all can be given only at this stage of preparation of final merit list, to give them the handicap. That in our school days, someone was a little weak, he was given a handicap for a flat race. Then you are given 10 marks of handicap when you are really suffering. At what stage? At the final stage, provided you come across on your merit from preliminary test, which many of them could not.
Academic score.
And yes, another word is very important, that is score. Merit score, academic score. Academic score, how it is assessed? The educational qualification, 10 marks. And by percentage, you will get, if 60% above 10 marks, their merit score is mentioned. Below 60%, 8 marks. Below 50%, 6 marks. And what is the scope of scoring in teaching experience? But court is invited to give a harmonious construction and reasonable meaning. But unfortunately, I was shocked to hear that the authorities were arguing directly against their own rules. They said, no, 10 marks will go there. But the rule doesn't say so. Your own desire cannot change the rule. And like if your lordship wants not to have the authorities to show that this statute has to be read not in its entirety, even not one single word, one single letter has a meaning that has to be completely followed. There are authorities, I'm just not giving the এটা দুটোর সময় এসে দেবো may I stop it?
All right, you want to come back at all right,
দু একটা বাজে আর পাচ্ছি কবে
আজকে নয় আজকে দুটো থেকে সাড়ে
For us, kindly keep it on Monday.
all right.
Or
Let him make his submission.
Yes. But the other thing that I was suggesting, if somebody else, some other learned council wants to challenge the values of this rule,
It can be done.
they may
in one
all
go.
argue together. Let them conclude, then we'll make our submissions. Number one. And number two, I don't know whether
the maintenance of proper discipline among government service. Like other employers, the government is also entitled to pick and choose from amongst a large number of candidates offering themselves for employment. But this can only be done in one condition, that all applicants must be given equal opportunity along with others who qualify for the same post. Well, I stop here. This is the basic principle. You are going for a public appointment. Teachers, they are not like any other job or profession. The teachers, they really create the nation. if at the end point of time they feel that we are out because we are not having some other qualifications, and what would the students feel? Nowadays, everything is transparent. Now I find some teachers are crying that our students are not respecting us. Why would they respect? If they find that teachers have got appointment through illegal means? And Article 1416 but has to be complied with strictly. And particularly in this case, that I would repeat, the direction of Supreme Court was only to fill up those posts which fell vacant because of the judgment of the Supreme Court. And he wanted to amalgamate them. Now, this being the position, my lord, so far the key. Now, my lord, the question would come, I'm sure, that another writ petitioner, not this client, though I was the counsel, that's a different thing. Counsel doesn't have any cause. There, my lord, this writ petition was moved. Let us see what was the issue and how the court dealt with that. Division bench judgment. First of all, the principle is that I am not bound by that judge, with the best of respect. Milord, definitely they can, Milord, cite it as a matter of precedence. Milord, the precedent depends on whether the points are good and decided. Now, this is settled law, Milord, even little bit of variation of facts, even one word, would completely, Milord, change the ratio. Now, kindly take Rashaka down. This judgment of Arunima Pal. Rashaka down. দিয়েছো? আগের দিন দেওয়া ছিল বলতে হবে নাকি আর্গুমেন্টের সময় আমার কপি দাও কাইন্ডলি
সবগুলো একসাথে করা আছে page number 24. Internal page.
Now, kindly come to me, Lord, page 2. The present appeal is directed against a portion of the impugned order, whereby the contention of the appellant that the recruitment process initiated in 2025 on the basis of the shade rules of 2025 could not be made applicable to the present appellants as they are to be considered under the recruitment rules of 2016 was rejected by reasoned order. So this was the issue. While considering this issue, the Honorable Court categorically records that since the rules are not under challenge.
Page number 24, internal page 24.
Will not kindly turn to page 24, the paragraph 34 of the judgment.
Second series of matters that we are working on, good matter.
That's very interesting argument. Kindly turn to paragraph 34, the awarding of 10 marks.
Yes.
Awarding of 10 marks is an weightage to be given on the basis of experience that is only expected that in selection process of this nature of kind, all the candidates are required to undergo the rigorous selection process. Now, how the deepest of respect, court will not contradict itself. In order to select the most suitable candidates, proportionate weightage based on the length of experience to the extent of 10 marks given to such candidates. So the first page says it should be considered contested by all candidates rigorous. And then section 10 marks weightage to given to such candidates. The object is to select and appoint an experienced teacher That was not the advertisement. As rightly pointed out, learned Advocate General and also Mr. Bandyopadhyay, appearing for the commission, that the writ petitioners are not coming within the purview of the categories in whose favor benefits and concessions have been extended. The judgment of the Supreme Court, they are not extended in paragraph 49 of the judgment of the Supreme Court. They are not candidates selected in 2016 recruitment process. In the meantime, they have not also applied for service in any educational institution. It shall be the duty and responsibility of state to ensure quality of education, and the eligibility criteria should be framed keeping in mind the interest of students. But eligibility criteria did not mention, even in the advertisement of the rules, that 10 marks should be given. If we accept the submission of so-and-so, then for the selection of the same subject teacher to different eligibility has to be applied. But deepest respect, this is just the other way. The eligibility criteria in the selection process 2016 is different from recruitment process 2025. Rules are more stringent and student-centric. The revision in the eligibility criteria is in accordance with the consonance with the NCT guidelines. Well, I fail to understand. NCT fixes some eligibility, minimum eligibility, nothing else. Anyway, therefore, here after considering all this, now the court says, when understood that this might lead to an incongruity, the court says in next page,
That was previous.
the recruitment rules of 2025 has not been challenged by any of the appellants. Now I have challenged this. I mean, this petition has challenged this. Therefore, this judgment of division bench that will have no application even by the precedence in any way. Therefore, this judgment will not cannot stand in the way, and particularly after the last order of the Supreme Court, where the Supreme Court has made it very categorically that only the final judgment has to be considered. And final judgment says these are all void. And even on their modification application, Supreme Court says no benefit should be accrued to them. Therefore, if the 10 marks was open for all, then at the eligibility criteria, it would have been said that you must have teaching experience, so that the other experienced people could have applied. But here also, the well-settled judgment of the Air India Transport Company. Whatever you declare, there was issue second grade hoteliers and third grade were given, which he did not notify this. It becomes bad. But in this background, I sure the rules is ultra-vires and should be declared bad. And secondly, if your lordship, that is in item 25. But if your lordship is not with me, then what would be the interpretation of rules? Kindly come to page 39, the rules.
25 to the
Dao, Joshua, আমাকে দিতে হবে না।
25 মানে?
item.
নাম কি?
You are referring to the rules?
Yes, yes.
It is here.
হ্যাঁ,
So we can look at it.
চলে যান না, আপনি
Rule
পরের দিন বলতে পারবেন।
26, 25.
25 rules.
39
হ্যাঁ,
এটার পেজ
বলুন না।
It's short, short.
হুম।
And then be followed by other advocates. May I have my lord?
ওইগুলো আসবো, দেখাবো সব।
Personal ground.
All right, all
I have to leave the court.
All right.
Thank you. Yes. I'll come back on Monday.
yes.
আজকে শেষ হবে না। আমি আপনার senior
এটা কি হয়েছে বলেছে ও ইয়েতে নেওয়া হ্যাঁ ঠিক আছে 25
হ্যাঁ, তাই তো, সেটা অর্গানো বার করো। কি আছে, কি আছে, এইটা কি? এই সময় তো, তাহলে আবার কি দেখাবার কি আছে? Now that the my lord's order was specifically referred by the Honorable Supreme Court, Lordship is well aware. No, I need not really trouble my lot with that. Therefore, the issues which are to be discussed are reflected and flagged in 7th November, 11th November, and 12th November, 19th November. I am really within the issues which was flagged by your lordship. Now, kindly come to me, Lord, the rule against. Without prejudice to the argument by the other petitioner that this is ultra vires. Now, if, my lord, some of the petitioners feel that if ultimately the rule is upheld, then what would be the
These set of petitioners are also freshers.
Yes, 25 and 44. 44. Item number 44.
I'll come to the item. I am at the rule now.
Yes.
He put
Now, will kindly come to me, Lord.
with 2K and 12.
Of 25 rules.
Rule 2K,
সেটা কি এখানে ছিল না?
interview list. In respect of SLST means in case of vacancies in the post of assistant teacher, a list of candidates prepared by the Central Commission to be called on merit. But every word, not the statute makers do not waste any word. That's the principle. To be called on merit for oral interview and lecture demonstration. Category wise on the basis of preliminary merit. Therefore, you have to first fix up the preliminary merit, then invite them for interview and lecture demonstration. And what are the preliminary score? That is score from written test. The test for upper primary and traveling and academic score in the ratio of students. What is academic score? That is defined in, that is indicated in the advertisement. These are the eligibility clause academic score. Then after you prepare the preliminary merit, you call for the interview. Then final merit list. In respect of the SLST, a list of candidates prepared category-wise on the basis of merit, which will mean in addition. It's very categorical. Whether the addition comes at this stage to what has been stated in the rule 2. Today I will stop here.